Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
This issue, what actually express themselves, defend themselves, you know. The more you become generous, you know, the more you do what? The more you create room for the court to be abused in the future. And that is what I have seen over in fact, since Chairman Wontumi case in start here, you know, the council and our lawyers of Chairman Wontumi from Apia Kubi, ABC attached, you know, they have seen abusing the court, you know, because the court allowed them to do that, you know. Apia could be quite free, Chairman Wontumi Ekofa attach, and he also wants to do that. And that is dangerous for Ghana's court. It's dangerous for the judiciary. It is dangerous because other people are watching, other lawyers are watching. Now, there are two things you need to look out here. Or see a judge ruling before Atachia was brought in as the lawyer. And secondly, how Chairman Wontumi, your static case way, criminal case way, na Apia could be any lawyer, no, how they have abused the court to this point. Now, the abuses I'm about to show you. Make sure case in the question, no, senior Chairman Wontumi ni Apia could be abuse the court, no. For some reason, the court actually did what? The court allowed it to go on. And I'm not saying the court allowed it to go on in a bad way. The court basically felt Chairman Wontumi needed all the time to make his case. But court now allowed that, you know. What Chairman Wontumi and lawyer Apia Kubi ABC Atachia did, and say they abused it. Omo making sure say sa chance na court dia mom no, omo be say no, omo de be good court no ho fi, omo de be chere say court no mumbu no. Now let's step back a little bit. This is a court proceedings. Nya opportunity me. Now proceedings we know, and this is what happened in court. It happened around the 3rd of June, all the way 3rd June. Satana case no koso. Now, you see this document, it's public document. And media a court. You can go to court tomorrow, they'll give you all the documents. We can also publish this tomorrow. This is not Kevin Taylor's document. And this is a document anybody can have access to, a court document. Now, on the 3rd of June, I said see your court. That is how Chairman Wontumi and then the lawyer Apia could be abuse the court, you know. And so the Atachia wants to do that from tomorrow. Now, that's 2 p.m. Date tonight, 3rd of June. And so accused persons A1 presents and present A3. Sorry. Present and represent A3. Now, the counsel, Dr. Justice Srimsai, or the Deputy Attorney General, basically, he was also the lawyer for Ghana. Let's make it simple. Now, so we study should you see a timer na case in the course and see how Apia Kubi, what he did in court. Any judge be only abutre, any court be they don't want to even listen to Chairman Wontumi no. And Apia Kubi that time ni no anka ka ushebu pa na nke this case do this point. But all these things, you know, Chairman Wontumi and the lawyers, they never spoke about it. All the things they did against the court, all the deliberate action they took, and no one say it was going to delay the case. No, the judge still had that had to accommodate. Omo ya nyoma could do point bia judge bia say be one person be Chairman Wontumi at the team or ding person or ya quick no or judge asam no anka say be obegina sa adwuma ne so nyina ajage asam no but judge ni nya abutre o wiase nyina ama Chairman Wontumi Emma Apia Kubi ene Chairman Wontumi mo disrespected court no on several occasions, but the judge still believes say it was a Chairman Wontumi enya fair hearing. Fair trial is very important because he is just an accused or yet somebody who has done it so far as we speak. But so when you now come back into court proceedings, now share idea Apia Kubi deliberately on your court. Na judge na cause the bufu. Now I say no. This is too much disrespect. Eya de nimtia doso. Just say we are lawyer paying awudi Chairman Wontumi enim but dia wo ye no I say we need the ho na opese ubu court enimtia na udi di Ghana for the atem. But what happened was that judge, you know, did not do anything. And when I said did not do anything, the judge could have stopped the case there and said, hey, Muni Bibia, the way you are disrespecting the court, you know, and I want to go ahead and write my judgment. But the court accommodated them. The judge sat and did not even react until at a point, Judge Rika said, no. The abuse is too much. You see, Omu to the point after Judge Nika say this is becoming like a strategy of Apia Kubini Chairman Wontumi. And to the judge at a point in court, the judge made it clear to them, said, no, the disrespect to the court, the disrespect to me, the disrespect to Obiano, deliberately a counsel and as a lawyer, deliberately changing things even in court. Case management or to be back court, no assistant BBR, all of these things, judge can say, you know, what Sha would say, Apia Kubino or a lawyer be I just say on canocre, I just say, oh, delay case, no, because in technical judge will be a bias. Now actually the cell, person jelly chairman want to me, and case in can do her. But this judge seems to say, Chairman Wontumi needs to be heard. Chairman Wontumi, the witnesses are supposed to come. Chairman Wontumi, whatever is provided, we need to. But it got to a point you could see, say, Chairman Wontumi and Apia Kubi, they were deliberate in their actions. They wanted to abuse the court. Per se, almost say case, you know. And I'm doing this and I say, that is the same 442 formation and at the end, attaching a PK free. They just want to delay the court. They don't want the judgment to happen. Into a attaching also called court or 6 weeks. On family study documents. Abra case near KWA. Now, my mention you see what court and why attaching to me respectfully to the court without the respect to the judge. I believe a case, you know, who disrespect the court, you know, who abuse the court, you know. Now, Mummy Ankoso, any uncle who they could see your court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti Judge ne say, "Hey, Apia Kubi ni chairman won't mean tiasie. Nyoma mo ebebria mama mo chance sebio mu bu court ne ebomfia mo disrespect court no mu delay case no o say saa nyoma na media mama say muntumi emfa nka mo asem no enkyere say mu betumi ebu court ne nimfia ana abomfia mu betuma disrespect court no o say de mi wi kyere say saa na mo pesa mo ye o say ye ma obi fair trial Yema obi hu kwan se ono so en defend no ho onfa konfombra be defend no onfa adanse fombra en be defend na se court ma hu kwan na court enya abotre na court anya okeke en kire se ubetum the court ni metwitwi form enti judge ka se wo Apia Kubi wo ne chairman Wontumi ene sa eye the accused person ade a mo ye no emwaye sa nyama we nyina si wo court. Did you ever hear Apia Kubi come out to say court no be bibi na court na mfa me? Did you ever hear the Attorney General come to say, this is what is happening in court? Apia Kubi abuse court, you know. The Attorney General did not have time for that. The Attorney General's job was to get a witness to cross-examine, was to get to the bottom. If there are there are things happening in court, Ubi abuse court. Now, it is not for the Attorney General to say. The Attorney General can raise objections and raise concerns in court, but the Attorney General, it is not his duty to make sure, an accused lawyer follows rules and regulations or court proceedings, the regulations. It is the court. Until right now, the judge is talking. The judge is frustrated. The judge has seen, Apia Kubi, any chairman Wontumi no, almost shut down on person who go court, say, delay case, no, until all the way from May, they started delaying this case. So, case where attaching Abesomi, nan can you say through June? So case we don't can say enter June. Apia Kubi ade oyeye because from day one not almost strategy. Delay the case. Now Judge Nesaka Saya or say the bedrock of criminal trials is fair hearing. Now at this juncture, Judge Nesaka Muntieno. This is all the way in May. The judge started getting frustrated with Chairman Wontumi Apia Kubi. All the way in May. Now Judge Nesaka say at this juncture, the court does not know whether or not the witness statement it has received in the name of Honorable Evans Adai is an addition or a substitution. At a point, now, I feel Apia Kubi akofa statement for Fraba. I feel that court now confused. Evans Honorable Evans Adai na oka witnesses no. I feel bayani dinim. After Saba court, Apia Kubi akofa Sani Panano assembly abase yemfa asem we hye. Like I say, right now dey na wo ye no. List out the brain na akwa di wom. After pay court and di nim. Yes, our court was akofa statement bi abase e akwa ne statement. Ki judge say onim say or substitute akwa ne free case ni mo. Say obi be shemo. Right now the judge was confused. E dey na Apia Kubi ye no. E dey na chairman Wontumi ni Apia Kubi. I so money da ho na omaye say omo be book court nim ti omo delay case no. This is May. And remember, before May, no my son, you may be my judge and bibia. But you see, anytime they walk out of court, no matter catch case in there, Bibioboko, judge Nina, they do some time. They knew what they were doing from day one. Deliberate delaying of the case. I idea from day one. Now, now when you move forward, judge Nina say, I do not think this sort of practice assists the court in the smooth delivery of justice. TNA, judge Nina say, I do not think this sort of practice assist the court in the smooth delivery of justice. I said, the appear could be no, and the chairman want to moya or quarter. There be no makase, no more delay court, no more. I say, sad dear way are more no. Menya sure say mo pese court no, e di juma send you say di juma. I say mo timu pobi say court juma di mo be say no. That is the statement of the judge. So the judge got an idea of what chairman want to me, and the appear could be no more ye. And it's on one case, no say, me who say mo ye bibi say, mo pesa mo say case no, mo pesa mo delay case no unnecessarily. Mo pesa mo shada na case we no, eye tintiana nipa, who say the echo. Judge no got frustrated. Remember, a deal has been going on for 5 months, the judge did not say anything. But it got to this point, now the appear could be too much. Appear could be the other court, no. And you see, say judge be our body timu poso be di bone. Na o time chairman want to me, case we can do me. Anka case we no anka say by a match na anka judge no, but you see the judge and the court accommodated all these things. These are documents. These are some of the things they did. Now judge Nicole Nimno, judge Nicole Mokasemi or say CMC, Case Management Conference, is to give direction and clarity to all parties in a matter and above all, avoid surprises. Or say, sa CMC no moye no, a Case Management Conference no, ni nyina say, say yebeko court ochna. Krata bi Attorney General, edeba bebusa eye Chairman Wontumi and the other accused, or say Attorney General be judge in front of eye dey appear could be enim. And as appear could be so, and a baby sebu or better to a year Attorney General witness anwa or send krata or bebusanina or the banner judge no send a bear yen quarter or being of a krata before bontinamba Emma a Attorney General because appear could be krata with the one fan so bebusami witness once or say CMC no nijuma dienina no. Na ya den yakwa CMC ni ebe bana apia kubi ashada dan no won say the onim say CMC na odin krata foforo nipa din foforo statement foforo o say sa nyoma na apia kubi ye no wa shada. Now uku edima judge Sakasa was saying, so when an accused person in the middle of a trial without leave of the court decided or decides at will to change witness in improper, and this is stated with caution to the accused person, the 1992 Constitution grants rights to all persons, especially in criminal trials. However, these rights should not be exercised in a manner that will degenerate into a pattern of abuse of the rules of court. And a court judge nekachire eyedien or kachire apia kubi any chairman Wontumi say munim bibi. The amoye nyina sebio 1992 Constitution eka say nipa bia wo ho kwan say sebio yanka ne kashaboa enhye ne yem obetumi aka na adwene obetumi defend no ho obetumi afro obi amanaba abeya adansefo amano o say your constitution kire say obia wo ho kwan say sebio obenya fair trial obetumi aka na adwene aka no kore ma yetie no o say na saa de na ewo ho constitution mu no saa eye tumi na constitution e de amaye say Ghana for yebetuma fa lawyer yebetuma ko gina court yebetuma ka say oh sebio we de menya hwe nipa we no ho bi we na ma dance for no o say saa tumi na constitution de ma Ghana ni bia no o say opeso o ma apia kubi ene chairman Wontumi muti ase say from nyoma o ma ye a o ma sheda ebu court nim tia ebu eye de constitution nim tia ema apia kubi continuously wa sheda eye de abuse court no see saa nyoma no sebio so muti ase say ade bi o maya o de ni atofo mehu se e follow pattern bi ade bi ade se utumi tena hu se we ni ade bi o ma form ho adwene se o mo beye o se saa de na den o mo eya abaye o musuban ene o musu no sebio ono oya judge no ohun ni pain face se apia kubi ene o mpese obebu court no Chairman Wontumi a oye accused person a wakofa apia kubi no oma bom tirimu po say court no be book court nim tia the court nim twitwi fom omo be say asem no omo be slow asem no judge na asem kan no say sanyema amu yi e wo be constitution defend obi but I say they said obi a mutirimu po de mo ye makama no atum ahwe wa we apia kubi we panyini why a lawyer che but I say why should that sell per se ubu court nim tia me judge ametie me nipa and also me tie obi asem but I say from time ongoing time coming no why say adia why ya no na saa de na wo ye no e kire pefe say wunim de wo ye why you say obebu court nim tia. These are judge no words and yet these are not my words. Now judge Nicodemus now say having cautioned accused persons. Now this is what the judge concluded on. Now, court concluded on this. Having cautioned the accused person, so it means the judge actually cautioned Apia Kubi. Cautioned Chairman Wontumi. Said, you are abusing the court. Court na mama found the kakrasa mufandi mujumano, mopesa mudie day, ebu court tia. For a judge to caution you, it means the judge has had enough. For a judge to say, dear moya no munchaso. Mama mu time too much, and from proceedings, you didn't see Apia Stadium, Apia Kubi object to it. Apia Kubi never objected to the statement the judge made because no one said the true, and the judge did not say anything out of what is happening in court. Saying Apia Kubi, the judge nekano, Tananka judge ni chatra. Apia Kubi would have objected and say, "My lord, this is not true. I never did this. I never did that. I will never." But you see, because Apia Kubi knew what he was doing. Because Apia Kubi don't him say or person delay case no or person abuse court no or person disrespect judge no or person judge ni bufu na judge de bibi no, he knew what he was doing. Anything a judge no question no said the omo ye no a follow party bi omo njai no, Apia Kubi didn't raise any objection. Now, having cautioned the accused persons, the court will exercise its discretion and adopt the witness and the witness statement as if the witness was listed as one of the witnesses and conduct CMC on same. Inti Apia Kubi, omdisa honorable ada any statement in the baya. Na at the end of the day, na nkeni se Apia Kubi difa back door dibe court. Court nigga so ni bibi. Apart from all the things you have done, some inconsistencies, abusing of the court still judging say magic in the statement, no. Mesa aba CMC. So the judge was not even supposed to do it. Because one, the witness now Apia Kubi edebano. In the first place, where you witness the dear film, and in the second place, the statement to that background, Sebio now witness didn't sign yet, and the Paul Sanka court, and so judge Nikazoni BB. Upon all the disrespect, most show me or court her. Upon all the disrespect, or witnesses show me. Upon the things you are deliberately doing to delay the case, still, remember the chance. Come to CMC, that is Case Management Conference, and come show me this new statement you have brought from nowhere, and let the Attorney General be here. I'll be here. I will look at it. I'll give you the opportunity. So you see, upon all the disrespect Apia Kubi show Judge Weno, still the judge gave Apia Kubi that respect. Upon the basic deliberate mistakes he did, they're deliberate. They make it look like it's an oversight. It wasn't an oversight because Judge not told Jimmy for. And Apia Kubi Debi Okacham say, "Oh, you're experienced lawyer. He knows what he's doing." So the judge knew from day one what Apia Kubi was doing. But you know what? Anka Judge Bianco about the timu pose or time Chairman Wontumi anka that day na ko be end case no. Yeah, because those were not Apia Kubi and not Chairman Wontumi, not only witnesses biabim. But you saw what the judge did. The judge said, "Still, I will give you the opportunity. Remember my chance. Somebody Evans Adai we come one. No problem. The statement from nowhere, we don't know where it's coming from. No, I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other, and come back again and put that person you want to put in the box for cross-examination." The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is that child is not even supposed to be heard tomorrow. That is what I believe, myself and my team, I believe say the disrespect from Chairman Wontumi Council 1, Council 2, no, it is too much. And the same strategy appear could be the same thing I attach and I believe said the court is not supposed to tolerate this. Now, Hadia, you see, when you read on the 3rd June proceedings, you ask yourself, say, but why was the court allowing this? Now, Mami Ridi Adewincho, this is what happened in court on the 3rd of June. Oh, sorry. On the 5th, right? Yeah. So, on the 3rd of June, I'm call court I didn't see any. So on the 3rd, almost on the 5th, but the judge had to address a adibia appear could be Chairman Wontumi ababe pie attachia is doing same, and that is the most dangerous part in this case. Now, Hadia, let's take our time and go through what actually happened in court. And these are some of the things that attachia is asking for. And these are things that are documents that he can even go to Apia Kubi and demand. But because he wants to delay the court, he wants to abuse the court, that's why they are doing this. Mama Cho, before Ochina Omako Court. Now, on the 5th of May 2026, this is 5th May, near June crowd. Now, they see a court. The accused person filed 2 witness statements out of the 5 witnesses they listed. Now, on the 6th May 2026, the accused person filed another witness statement, making 3 in number. They, however, informed the court of their intentions of filing 2 witness statements in addition. The court conducted CMC on the 3 witness statements and proceeded with the trial with the anticipation that the 2 witnesses, the other 2 witness statements will be filed by the accused person before the end of cross-examination of the other 3 witnesses. So, I'm file witness cases, witnesses. Say, sa nipa we and your call case management, your person omoba. So, on the 6th, the accused person filed another witness statement. Remember, on the 5th, the accused person filed 2 witness statements. Now, out of the 5 witnesses they listed, inti now or say or nipa or witness statement 5 Sibu wa file. Now, what happened is on the 6th, even though on the 5th, okay, I say 5, on the 6th, a buy, afi, or say they can only file only 2. But during the CMC, that's the case management, they said they were going to file 5. Omobedru court on the 6th, they are going to use only 2. Now, means 3 now I also file, famba. That's fine. The court allowed them. And then you can see, say, it was a deliberate thing they were doing. Oh, yeah, the nipa 5 November. Omuni ebe from our bad kim. Abeka omanu asem. Ne atuto omano. No mabua me with a Chairman Wontumi. Afi could do court pena dani. Oh, yeah, the new pen ebe bande. Abra, bodin kai aye case management. Judge atia say, oh, nipa num nebia and ombeba. Nipa num ne ya file. Ya be free we and the ochani ya free we no. What they do, they say, omo koye sa meeting you no mudru court pe. Na apia could be we change bibia. Instead of 5 statements, both are adani 2 and adani 3. And this is what transpired on the 5th, on the 6th of May. Now, don't worry, however, at the end of the cross-examination of the 3 witnesses, the accused person had not filed any additional witness statement. Go ahead still. And then they did what? They cross-examined the 3 witnesses from Chairman Wontumi. Now, the funny thing is, time cross-examining of the 3 witnesses, the accused, Apia Kubi, they have still not filed witness statements of the other witnesses. Now, the court cautioned the accused persons and gave them 7 days to file additional witness statements if they are so minded. Into my court bufuye, judge in bufuye. And I can say Apia Kubi. Sanko fuya, I will say Omobabe witnesses are much Wontumi. Miami Babe warn you say Omo Empe Omo Wasema, Omo Branom file state because on paper, the CMC case management, actually say, I was some file near to be called any more case. Into my judge bufu your court. And I said, Yamoyano, Yanse Bienim, yɛkɔ ne yɛkɔ case ni nyinaa ho adwuma behind the scenes say nipa dodo say na ɛbɛkasa we na ɛbɛtɔ yɛbɛduru pɛ na wo ɛyɛ apia kubi ne Chairman Wontumi nkɔfo ɔsɔ mbɛkasa no na sebio yehu bebi ɔmo nam ɔmo statement so ɔmo famba enti why how are we moving forward and all this the judge had the patience to listen. So at the point the judge said no, I need to send a caution to ɔmo jatum so ɔmo witnesses for Chairman Wontumi. Now this is what happened on the 25th of May. So from the 6th, the 25th of May, something happened. On the 25th of May, 2026, the accused persons filed a fourth witness statement in the name of Honorable Kobna Ochredaku Mensah. The court conducted CMC on this witness statement and proceeded and adopted the evidence in chief of the witness. Cross-examination commenced. The mouth of the witness was sealed and matter adjourned for continuation of cross-examination. Inti right now naka witnesses mienu Chairman Wontumi appear could be filing. So judge ni ma sa question no a omu say judge ni bu fuba no eno omde ba akoba so ye de ba akoba na ba akoro na ye gabi Kobi Ochredako the former Western Regional the minister akwada the nise petuo no gibi no num wi no. So when the guy came to court, they see and they say, appear could be more making sure say one kasa. Cross-examination you better to a witness no. Appear could be any Chairman Wontumi by almost so effort strategy we say witness and he say Obiana no kasa, almost Selena no, almost person answer to anything. And that day no, you maybe or court and a court case, you know something, let's adjourn yen two case in shedder. They use another technicality to prevent the witness from speaking. When they were in court that day, Saturday no so no, I was anka Kobi Ochredako Attorney General in Samano no, ono so to obudi yebusana, ono so person bekasa. Emma waste time Emma appear could be use delay tactics or court. Eka say because of something, me client into me kasa because of Emma Aquano sorry kofima yentumi antena case so. Emma judge in this case sheda because the time not time ne court. And remember, from the 5th of May, judge need to make nyadian abutre for all these things. From the 5th of May to the 25th of May, no, anka witnesses ni anka kade anka cross-examine but appear could be deliberately or make sure say court no schedule no or best schedule no because he wanted to delay the case. He never wanted the case to end. And these are some of the things they did in court and the ABPH attaching us so picky from here. So I just say a baton. We echo kakra no da come away now we have delay. So it's a delay strategy. Now the same court, I'm sure their court is here. They see any before continuation of cross-examination, counsel for the accused, that is Apia Kubi, person informed the court that, let me take this, before continuation of cross-examination, counsel for the accused person informed the court they had filed a supplementary witness statement in respect of the same witness. In terms of our court, I feel that Apia could be catching the court to say, Kobi Ochredako. Or the statement I had tuma yebebusebusa na no asem no. Apia could be say was filing another statement, akasa statement no home. Until say a beji statement na tumu no. Sa Kobi Ochredako no to mean kasa. But remember, answer na witness babet na dakem, ni ebusebusa na no nsem no. Your very BCMC. Judge no, on it two lawyers no eshia behind the scenes. No mun nyina je questions ebe bubusa nipa no atum ye wia na ya de ama court no eno na ye dru court ebedi hu nkomo. Now what Apia could be did and say statement na Kobi Ochredako edin kan attended in say eno na the witness statement Attorney General ebe hwe so to na no ade chi bi no betena court Apia could be catch the court say ne witness no esa another statement bi or person de saka the statement no meaning sa first statement na da no yentumi ndi ho adwuma yensan kɔ biem na yenkoya another CMC case management behind the scenes na first supplementary statement in san kan the witness statement no meaning it's a clear strategy to delay the court. And all this while na judge no won't show any anger. The judge was still accommodating Apia Kubi. Kobi Ochredako first time almost Selena no mama nankasa Apia Kubi making excuses. Adechi bi omatnasia Apia Kubi catch record say oh me witness no one send be can you rempo afinti e side be ka ho na eno no because court engine to munti they are not going to allow a cross examination omo pese court ne gin supplementary edien na asam ne saka ho ansa na yato aso meaning the delay tactics is in force. They just don't want the case to move forward. Make sure the delay of my bedroom there, or my abuse court now, and the court should not allow Atachia to even make a statement in court. The judge or the court should not even entertain Atachia because Adia appear could be a year from day one. That is what Atachia is continuing, and it also pay 6 weeks, And when you give him 6 weeks, you ask for another 10 weeks. Now, my mentor abuses Nibi. Now, so when this happened, now the judge started getting frustrated. The judge started getting angry because it looks like, say, the taxpayers' money, every single minute we are judge, we are basically paying the judge. Every minute we are telling general court, we are basically paying them. So the judge is like, you know what, the taxpayer, we cannot waste their money like that. We need to basically move on, do the thing. I said, "Debiano, I appear community. I want to be bar witness, crab, witness about another document. Ya printed document. Obianum so where they will some question or the witness so a kai bibi in TSC. Yen to be in Kasande, Yen Franco count and son and witness nakasa. Now the judge went something happened. Now, notwithstanding his so this is what happened. Notwithstanding this irregularity, the courts obliged and conducted CMC on the supplementary witness statement and proceeded with the trial. Inti appear could be by and so yes, I was statement be a could be a kwasa account and agree into a account and I consider no problem. Say mo per se supplementary and you know the count court to because we cannot make this thing delay the case. Yet to me, must have supplementary statement we end delay case. Into the judge was patient, and the judge said, you know what, we whatever you want to do, we will accommodate you. So the judge accommodated the appear could be guy again, and also and the judge allowed that to happen. 3 times these people have abused the court. The judge did not say anything. The judge wanted the case to flow. The judge did not want to be seen as biased. Judge Bia said, he or she would not even entertain this nonsense. He would just move or she would just move. But this judge took her time or his time to be taking all this nonsense from Apia Kubi and the chairman Wontumi. Now, make sure they see it. Now, the judge decided to speak after all these things. Now the judge decided to speak because now I feel it too much. Oh, when said some to me 1 week I cannot. Now we are spending 3 weeks or a month on it. Witness a bit to me cross examining in a day. No, we are spending 2 weeks on one witness. So the judge started getting frustrated. Said no, I didn't know and I say more abuse court. And I say much than person will say delay Ghana. So the judge says something. I'll say I have painstakingly gone through the trajectory and conduct of case management conference in this trial, mainly because my attention has been drawn to a witness statement filed on the 28th of May 2026 in the name of Honorable Evans Adai, who intends to give evidence for and on behalf of A1 and A3. Also, when you would say at Nasi, at Kinkai Case Management Conference, that is CMC, meeting on behind the scenes and Sani Abakota Bekasano, I will be adding document bachelor judge. So when you be someone, also when you would say at a study ako back ako check a case management conference or no accused any the prosecution not say and when we say one witness a friend or a Honorable Evans Adai or no na eba bema de evidence obema obe yebetutu no emana de evidence aba be defend chairman Wontumi and the third witness no or say the name on this witness statement is not one of the names listed in the list of names of witness filed by the accused person. Judge says, but and the court no. You said there are 5 accused people. The 5 witnesses are omobabe day. Yeba cross examine. In fact, 3 ya cross examine we aka 2. But you see a court no. Afemishan kratedima papa your friend Evans Adai no. Ni dinim. He is one of the people so I was who accused. A lawyer and I said who appear could be. You need to make sure he is available. Why say what sabete say a nipa we babe kasa amachema Wontumi but you be do court in no sa edin what is going on judge na appear could be dear juma na wo ye ne sa no because nipa o say obeba betena say me atoto na no ama be protect a defend chairman Wontumi no list ma hwemu nyina menya botra ko CMC, that is the case management conference mako study names are listed the breye say eno sankofo we na wo be from e de o ma betena dakem ema omo se be yatoto ma no a omo defend chairman Wontumi but me do court ya no sa brand e ni dinim die nti na wo ye sa. The judge started getting furious. Because now it say appear could be any chairman Wontumi no omo imagine say person abuse good court then see person case in because that court no. And this is something that happens so many times and one day this is something appear could be any chairman Wontumi yeah they never spoke about it. The judge did not speak about it. Even the prosecution and the AG never came out to say this is what Appiah Kubi is doing in court. There was never a day the Attorney General came out to have a press conference to tell us to say, Appiah Kubi mo, to the list but say witnesses way on Bekasa near year from na judge. We never heard the Attorney General make this statement in public. All along, the Attorney General was also focused. The Attorney General allowed the court to deal with these things. But say Attorney General be or pay public sympathy. Or say, I'm for merchants or ejuma. Anka this will be his talking point. Anka this will be his defense. He will be all over the place saying the reason why the case is not done is because Appiah Kubi say, the court document is they go and check court proceedings. But the Attorney General did not do anything. Because the Attorney General at that point, his focus was to get witnesses to cross-examine, to get the truth out of witnesses. Until Webu someone say, I feel the judge no ya mean judge no technically the all can say Appiah Kubi a twa court intro Appiah Kubi deliberate na dida ho e na o twa court intro on person be de no o person delay case no na yanko enim. The name on this witness statement is not one of the names listed in the list of names of witnesses filed by the accused person. It is not for nothing that the practice direction on case management provided those direction to be taken or see enyekwa say ye case management conference. The reason tia case management conference and then say send ye be ya Attorney General per se or the prosecution witness ba wo Appiah Kubi ubehu nipa kro ubehu omudin ubehu nipa dodo send ye be ya wo so Appiah Kubi what the prosecution accused witness ba yes you ubehu nipa kro ni din o say enye sa kekenti na CMCO butai bi tare chire na se wo beba court na ya meet na wie na betena court na de adefo fraba means se wo no court no person be court no intina judge no to Appiah Kubi for say dia all ye no or say case no nani da ho no o book court na nimtia. He is disrespecting the court like deliberately. Now who read the document where a court document you can go and ask, they will give it to you and media. Now say o person who follow proceedings say see o court. After this, something happened. The same court. I'm reading the scene. They can't be see the attaching so the same strategy Appiah Kubi taking and no have been no taking the disrespecting of the court, abusing of the court. So court more opportunity to pay. They'll blow it up. NPP lawyers way Appiah Kubi and attaching way 2 days. Obe say no man could do 2 months. That is why we have to be careful because court you don't allow these things to happen. The moment we give room for that, other criminals, their lawyers or their counsels, that will be what that is what they will be doing. Ochina omoko court into you be menya abota medjudwa we mu akiro. Now, when you move ahead, this is what it says. The bedrock, I wanted to read this is the latter part of the second one. Change in circumstances to cause a witness to be changed, substituted, and added. It is for the accused person to seek leave of the court, giving reasons for same, and not the situation this court is confronted with presently. Judge Nika say, we are accused lawyer, who Appiah Kubi. Now, so person was a witness, and now open say witness be changing the D, and now we need the D from, and now obi for beshema. You have to follow the right procedure. Unim send ye no court ya, but what Appiah Kubi yen say, Obeka say Kevin Taylor na ebet na adakem, ade bechi ye beba no na Kwame Amoako. Ye busa na osi o ene yan agenda case ni enkomra menko Kevin Taylor. Inti judge ni kachen said that thing now wo Appiah Kubi wo ye no o good court ni ma say o disrespect court no. In fact court ni chance or the amount say be the lawyer for Chama Wontumi na to me protect and as a defender no. It is looking like say what the sa opportunity no what the abuse sa opportunity no. It's judge ni call point to explain to him say ye nya sa adia wo ye no enye wo na wo ma case ni delay because we are not supposed to do these things. What the witnesses list bar also making sure so we so but to medru court now witness list no ebi ayra obi din nim enti na judge na kire say ye adwuma say court mra no ho wunim dada so obese say obi krampa there is a way you do it, there's a way you go by it, but you just don't appear in court and say me change way without any formal approach to it or formal a way to approach it. It's not judge say no what is going on no say case no oh disrespect court no, oh abuse court no. Now, mommy and Koso, any uncle who see your court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti Judge ne say, hey, apia could be the chairman won't mean tiasie. Nyoma ma ebebria mama mo chance sebio mu bu court in abumfia mo disrespect court no mu delay case no o say saa nyoma na media mama say muntumi emfa nka mo asem no enkyere say mu betumi ebu court na nimfia from nowhere we don't know where it's coming from no. I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other and come back again and put that person you want to put in the box for cross-examination. The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is you give people the benefit of the doubt. It does not make you weak. It's what it does is that it makes everybody understand out of your courtroom, because and you'll be in a raw courtroom. What it does is say that leniency, that room you give people you even think are abusing the court. You know, when you do that, what happens is you make the case more transparent. You don't give people the room to go out there to insinuate, to create an impression. Because you see, perception, when it's attached to a crime or a case in court, it basically dissolves the potency of the case. So I think what this judge was doing was that he didn't want to give anybody any room to say the accused person is being treated unfairly. Even though there were some things that this judge was supposed to stop. There were some things this judge was not supposed to entertain. A lot of abuses and disrespect to the judge herself or himself or the court, the judge was not even supposed to allow for some reason, because the judge wanted Ghanaians to understand that this case in court is not personal. She has no personal issues, or he has no personal issue with the Attorney General or even the accused. And that the judge's main focus was to make sure that this case, at the end of the day, whatever the accused has to present, they present it fully. And whatever the prosecution have to present, they present. So the judge was basically avoiding that perception that the accused person is being mistreated, the accused person is being gagged, the accused person's lawyer is not given the room. But you see, but the more lenient, the more diplomatically lenient the judge is, the more advantage Apia Kubi and Chema Wontumi were taking of the court. So you see, now when you give people the room to protect themselves, you give them the room to basically be heard, they abuse it, they take advantage of it. So we are judge and Kaden and Kobe. But all these things happen in court. All these things happen in court. None of us was told about this. But these people are the same people. Right now, what is Atachia doing? Atachia is doing the same thing. But I'll go back to the ruling. About what happened in court. Nobody will accuse anyone of being hard on anyone. And it's all and I will study there. You can see clearly say from day one, Apia Kubi or Shadan or abuse case, or abuse court, and a delay case. Now, shall you see it? Judge Nikasawi, Apia Kubi Ekasaya, what did he say? I have a friend in Canada. He just texted me. He just told me say I should call the witch doctor Kukubunzam. Canada for any day. Xavier Kukubunzam. Xavier, I'll call you after the show. Now, Judge Nikasawi, Apia Kubi also responded to what the judge said. And then okay. Or say, counsel for A1 and A3, that is Apia Kubi. Or say, we have a witness statement of one Honorable Evans Adae. It was filed on the 28th of May 2026. I pray that the said witness statement be adopted by the court as a witness statement of the said Honorable Evans Adae. So, formally, I feel na all catch the judge and say, sir, witness na, judge Niko CMC some time back and di woma apia kubi mu yifri mu no afa na apia kubi ka say ai afa na the witness no edin ba na statement nti yanko CMC ne yanko discuss biem. So you see, anytime I'm just say if apia kubi had an issue with the judge's pronouncement on the delay tactics, on the disrespect and abuse of court, and apia kubi be raise an issue and say, Your Honor, or whatever, your lordship. In fact, what you are saying, without due respect, is not true. But you see, Apia Kubi didn't say anything because what he has done, no, on one him na all year, na or abuse the court, no. What if the judge did not have that patience, was not professional enough, has no interest in the Obika, just focusing on the case, and like a judge in a react here, press conference and Apia Kubi Babe. Imagine the judge threw out this their witness statement out to say we have gone to CMC and that we came to court and you're giving us a different thing. Can him the Apia Kubi? Do you know the kind of impression Apia Kubi chairman Wontumi they would have come out to put? Can him the Kofi Benton Babakano Abontene? Can him the NPP dogs? You know? Do you know how they were going to lawyer for somebody? You know? The accused lawyer Etnim Etro and I said the prosecution lawyer. No? Now, judge, a really a year Apia Kubi case no that day, no, because that day na Apia Kubi call court so oko catch the court to say on your lawyer to chairman Wontumi bi no. Judge ni tie ni nsem nyina no. Na Apia Kubi argument nyina say judge no empintwen so. Because we yi no free say on your chairman Wontumi lawyer bi no. Chairman Wontumi ko fa another lawyer ntima judge no emfa the judgment mba. Anything Apia Kubi call court that time. So the reason why Apia Kubi call court no nani nyina say okokache judge say menye chairman Wontumi lawyer bem even though what she date our judgment ba no me Apia Kubi be say o twentwen o judgment no so because me enya me na me be chro written submission no me dia me ko obi na e ba be chro. The question here is there na judge ne ka that day na Apia Kubi e ba court be ka say onye lawyer to chairman Wontumi biem na in fact because onye loyalty written submission no judge remember from the judgment in back now because any on the better written submission or address that say lawyer for bar which is attaching on the better. But the question here is the written address and not submission from the lawyer after the case has ended. Not judge actually judgment, you know, does it really affect the case? In law, normal law, judge it's not kunduma. So the phone we bar and no and a judge no esho hon edibuan asem. Say what the pen we bar and no and a judge no issue. Say accused no the pen we bar no can say any evidence and no a judge no share. The judge is just looking at the pen. Now say accused no ed we bar no can say we need me evidence that the judge is just looking at this. Lawyers mienu a omudi accused and also whatever enim lawyers omo ho the accused lawyer and our prosecution no the omo dwene efa asem no ho no their personal opinion which is the written address no. At the end of the day, is it an evidence a bit may affect the case nana? And is that two teams Abo and Ra. Croatia Ashe Ghana 2-1. Now, two teams no el field in the Super Bowl. Your FIFA or manage the whole event. There's a referee in the middle of the game. Two assistant referees. They are match commissioners. Born na ye bono pitch this no. There are rules. Now, your bobo ni wie. Ebia Ghana ne eyedian England the boy ene obian shibi 0-0, right? There were some nyome bia esi or pitch no so. England goalkeeper na efri in the box ebe tackles. On a normal day, ushe FIFA rules, any game rules are a red card. The keeper left the demarcated zone was odini juma stepping out, whether he touched somebody or touch a ball cry. At the end of the day, you look at another red card. So, or to make a ball cry out of his box. Now, and only who finds also question or tackle be no be tough for ma. That ref keeper no so then sakabo, then sankabo, then sakanipa red card. That's how it is. Now, Ghana saying another chance. Now, omokoshe na in the box a defender a clamp Ghana a player down. Now we now ball no because he needs to defend. He needs to clear that ball. So then I can ball no. Now the player who is attacking goes down in the box. It's a penalty. That's how the rules are. Now, so nyama when you see your pitch so referee name, assistant referee so commissioner so yen you FIFA president put to now you referee no bar abem say 0-0. whatever the coaches say at the press conference does not change the final score. After game, the coaches can meet the press 50 times. Whatever England coach in the after the game, after the 90 minutes, plus other time, after the game, what matter? They see your pitch, their time within that 90 minutes and time added on. So that 90 minutes, that is what the FIFA regulations recognizes. So Ghana coach a press conference 50, and then he speaks about how he's disappointed in the referee. Now it will not change the goal line, the goal scores, the score line. It will not change the point build up. So England coach press conference 50. Now say Ghana coach journalists for Shannon can say, "Oh, Mr. Coach, how did you see the whole game?" His opinion about the game, how his team played, how the opponents played, the tactics he played, how the opponent. It does not affect the final outcome of the game, because the final outcome, the coach's ideas and opinions does not matter. The final, what matters is referee no GM decision no take here and the score line at the end of the day and the point everybody got. Our coach can express his views, and in law, the Atachia is a coach. Now in the middle of the game, FIFA him say, Brony when a coach. Now your ball game na mani bedu 80th minutes. Now Brony nigga say yemi ya ya. Now say free pitch na so kofie. Now say another technical person ebe some say on a coach. That person's opinion on that game. Say your pawn game na say coach no be take over from Ghana coach no. So in a press conference on to me nkase, I don't want to accept the outcome of the game because I took over from our coach who wasn't feeling well at the 78th minute. It does not work like that. So, coach now beji baton free the sick coach one or coaching for the next 12 minutes or 22 minutes. The issue here is